Hello, everybody, and welcome to the next in our landlord law lockdown training. And we're back with solicitor and JMW Solicitors partner David Smith. And the topic of our lockdown training today is consumer law and why ignorance of consumer law and failing to take it into account can actually cost you quite a bit of money, can't it, David?
Well, yeah, unfortunately it can, and it's something that people don't fully appreciate. And the number of times I've had people say to me, "Yeah, but it's in the contract, in it," or words to that effect, and that's just not the way things work.
So we're going to look at 5 consumer law issues today. So take it away, David.
Great, thank you. So, as Tess said, I'm a partner at J&W Solicitors London. I specialise in residential landlord and tenant law and things that are that fall around that, which takes me to all kinds of unusual places. Um, there's sort of an inherent artificiality to some extent in talking about consumer law, um, as if it was a thing. In that there are pieces of legislation that people think of as falling within consumer law, but the reality is almost all stuff we talk about in landlord and tenant law is to some extent consumer oriented. I mean, having Section 8 notices and Section 21 notices and protection from eviction to some extent is consumer law, because it's there as a general objective to protect consumers. So there's an aspect in which it's a slightly artificial topic, but there are sort of specific things that fall more strongly within it, and I've picked out sort of 5 themes. So the first of those is penalties. Actually, this is pretty old common law stuff and dates way back, at least in its original version, to the sort of 1920s, and a case involving what was then called the Dunlop Pneumatic Tyre Co., which probably gives you a bit of dating on it. So it's actually old common law, and the key point about it is that a contract cannot include a provision that is penal. So the penalties for breaching a contract are putting someone into the position that they would have been in if that contract had not been breached in the first place. What you generally can't do is put in any kind of punishment effect in a contract, and if you do, then those provisions will be considered to be penal and will simply be struck out of the contract. And the most recent case on this, though, comes from the Supreme Court and is the Beavis versus Parking Eye case, and comes from a run of sort of cases around parking companies that charge you in private parking enforcement companies that charge you inordinate sums of money for parking in hospital car parks for too long, and other places, or parking at McDonald's for more than an hour and a half, and things like that. So contracts can't include penal provisions, only costs that are genuinely incurred. So, for example, a penalty for late rent payment isn't possible. You can charge interest on the money, but you can't charge a penalty. So I have seen contracts from time to time, tenancy agreements that say if the rent is paid late, you are liable to a penalty of £5 per day. You can't do that. You can, in theory, charge a pre-estimate of loss, and there can be a degree of swings and roundabouts in that. So it is legitimate to say if the rent is paid late, you have to, or it used to be legitimate to say if the rent is paid late, you can charge you have to pay £30 for an administration charge for sending letters. If the rent is late, you have to pay interest. It used to be legitimate to say if the property requires cleaning, we will charge you £100 for cleaning, on the basis that the average clean costs around about £100. In some cases, it will cost a bit less. In some cases, it will cost a bit more. But it's a swings and roundabouts thing. Now, of course, it's important to bear in mind that all penalty clauses are now effectively restricted by the Tenant Fees Act, and in practice, it's impossible to put any fixed pre-estimate of loss into a contract at all, because the Tenant Fees Act will ban it. So you can only put in obligations to do things and say that you must pay the costs of those things in most cases. But it still remains the case that it's possible to write clauses that are penal and that would still be prohibited even with the Tenant Fees Act in place. And of course, the Tenant Fees Act doesn't apply to all tenancy types. It doesn't apply to lettings to students from universities, for example. It doesn't apply for non-housing act tenancies, and people still attempt to put penalty provisions into those. Those are not going to survive because of the common law prohibition on penalties.
I suppose another way of putting it, David, is that people can't make money out of someone breaching the terms of the contract. They can't
Yeah,
make an extra profit out of it.
yeah. I mean that sort of putting me back to where I started, really, which is that the penalty for breach of contract is putting someone in the position that they would have been in if you had
Yeah.
not breached it. It's not putting them in a better position than that. It is making good on what you have done bad. And it kind of the same point arises actually when we talk about tenancy deposit deductions and people and the idea of new for old. Um, Obviously, there's always an element. For example, if someone damages the walls and you have to repaint them, there's always going to be a degree of new for old baked into that because you're going to get a freshly painted wall. But you can't willfully obtain new for old by replacing your 10-year-old sofa with a brand new sofa and charging me the cost of a brand new sofa, for example. So it's the same kind of principle that underlies a lot of deposit deductions and something that a lot of landlords get annoyed about with deposit deductions because you can't buy a 10-year-old sofa. But the point is that you're not entitled to go mad on these things and put yourself in a better position than you were in.
Can I just chip in here and mention, I assume everybody's able to hear us. I forgot to do my normal, can you let us know that you can hear? But I'm assuming as nobody's complained, you can all hear. And also say that David will answer questions if we get time. So if you do have any questions on the subjects that he's talking about, you can pop them in the chat and we'll deal with them if we get time.
Great, thank you. So moving on, let's talk about something more different. So I want to talk about unfair terms legislation. This is actually originally an EU legislation. Oh, good. People can hear us. There we are. There's people saying they can hear. That's great. And also saying that they're interested. So even better.
Excellent. Excellent.
Always a good start. So unfair terms legislation is originally an EU piece of legislation. It's based on an EU directive and was originally enshrined in the UK with the Unfair Terms and Consumer Contract Regulations. They've now been ditched and it's now found in the Consumer Rights Act, which also, of course, means that it is, in effect, EU departure proof and is now essentially part of UK law across the board. And what unfair terms legislation does is it says that where a trader, and that would include a landlord or anyone acting in a business type capacity, is providing a contract to a consumer, and that contract is pre-written, i.e., it's not individually negotiated from a blank piece of paper, then those terms in that contract must be fair in the widest sense, and if they're not fair, they are unenforceable. So this is quite a complex issue because the first thing about it, of course, is it undermines the principles of freedom of contract to a large extent, which is obviously quite a traditional UK common law principle, or English common law principle, sorry, because it's not a common law principle in Scotland. It's quite a traditional English common law principle that parties should be able to contract on any terms that they see fit. But unfair terms legislation undermines that to quite a large extent. And of course, the reality, of course, is that it doesn't undermine it at all, because in fact, if you do write a contract on a blank piece of paper from scratch with both parties inputting, then the unfair terms legislation doesn't apply. So it doesn't undermine freedom of contract. What it undermines, in fact, is unfree contracting, which of course tends to be the case very much in residential landlord and tenant law, because landlords and agents generally present contracts to tenants and they're not really open to extensive negotiation about the terms of those contracts. Perhaps more so increasingly now, where there is a bit more of a shortage of tenants. But certainly in any market where there's no shortage of tenants, then the ability to negotiate deals is pretty limited. I mean, its main thing is to be targeted at onerous or unbalanced clauses. So classical examples of these kind of things would be reserving other money as rent, so that you, for example, if the tenant pays you a contribution towards the utilities, you then say, well, the utilities are to be treated as rent, so that I can evict you if you're in rent arrears. That would be a classic example of an unfair term. Or an unbalanced break clause, for example, the landlord only having to give 2 months while the tenant has to give 5 months notice, something like that. So onerous or unbalanced clauses, or just the really bonkers clauses that sometimes people put in, that the tenant must not wear shoes inside the house, the tenant must vacuum the house twice a day, sort of slightly extreme stuff that some landlords want to put in order to try and preserve their house, but not really accepting or understanding that, one, these clauses are effectively unenforceable in practice, and also unenforceable as a matter of law because they are onerous and just impracticable. So you've always got to take those into account. The other area this pops up is letting agents' terms of business, and the classic example of all of this is the line of cases involving the Office of Fair Trading and Foxtons, and the range of cases that came off that, relating to renewal commissions. So agents are, of course, also traders, and the majority of landlords are classed as consumers. And so in those cases, agents are bound by the unfair terms of consumer contract regulations and can't impose onerous or unfair clauses. And so the classic three sort of areas of clause that were held to be unfair were clauses that where the landlord sells to the tenant, where the agent seeks to demand a fee for that. Clauses where the landlord sells property to another landlord and the agent continues to demand a fee for the tenancy on an ongoing basis, even though the landlord no longer has an interest in the property. And then renewal commissions, where the tenant renews and the agent has no involvement in the renewal or in managing or collecting rent, and is basically just trying to take more money because they found a particularly good tenant on that occasion. So those are all examples of the situations where unfair terms works also in landlord's favour in that sense, and not in agents' favours, of course. But it's something it's sort of value neutral, and it's there to protect against unfairness generally.
We've got a clip of you in one of our workshops, David. I remember where you said that that being rewarded for having found them a jolly good tenant is not counterbalanced by them perhaps having to pay back their commission if the tenant turns out to be rubbish.
Well, yeah, I mean, some agents do that now. Some would do. Some would offer that unofficially, but won't put it in their contract, so that's no good to them. But yeah, it is possible to charge renewal commission in certain circumstances if there's a counterbalancing factor. I mean, one example that actually no one really does, but you could do as an agent, is if you offered a choice. So, for example, your commission is 10%, but you have to pay a renewal commission, or it's 12% with no renewal commission. That would be a legitimate mechanism by which renewal commission could probably be charged. It's not been tested in the courts, but the Consumer and Markets Agency gave that example in its guidance on unfair contractual terms.
We've had some questions, but I think we better move on because...
Well, I'll just answer two of these really quickly. Someone said, is it an unfair term to say that you don't accept pets at a property? No, not at all. Fairness is not it's perfectly unfair to say you don't accept pets, particularly if you've got a justification for that, like you've got a freehold if you say no pets, for example. And the consequence of ignorance, I sort of alluded to this, but to be more explicit, an unfair term is simply unenforceable. The court will simply draw a line through it and will treat it as if it wasn't there. So, unfair trading. So slightly different to unfair terms, but sort of within the same sort of general sphere. We have the Consumer Protection from Unfair Trading Regulations. And these deal with generally unfair trading, and they fulfill the role originally served by the Property Misdescriptions Act, but with a lot more stuff baked in there as well. And it covers all kinds of unfair trading, to be fair. And it covers things like boiler housing, where I put pressure on you to buy something and saying it's going to go if you don't buy it this week. Or where people go and muscle their way into old pensioners' houses and pressure them into buying enormously expensive Hoovers and other weird and wonderful things that they sell. It covers bait and switch, which actually comes up in the property sector. So the example that you sometimes see now in London, or you were seeing pre-COVID, obviously, was where somebody would advertise a property in order to get a tenant or someone to come and view it, and then say, "Oh, that property's gone. We've got another property. Look, just here, round the corner," which was nowhere near as good for the same price. That kind of deal with that's an unlawful undone for trading. But it also covers misdescriptions of property. Um, um, it also covers misdescriptions of property, where you describe a property as having features or not, or ignore or elide specific features that it should have, that you should have made clear. And breaching this is a criminal offence. And there's a lot of case law after the old Property Misdescriptions Act should apply to a state agency, but it also applies now to lettings agency. So classic examples here are, for example, taking photographs of property only from a specific angle to hide features, not mentioning critical items in the description, or giving a description that's just untrue or misleading. For example, suggesting something property has features it doesn't have, or suggesting it's near to things that it's not actually that near to. All of these kind of things. So loose descriptions.
Quiet.
Sorry? Yes. Saying a property is in a quiet area or sought after. These are things that people should be very careful about using. And it's important to bear in mind that it's anything that that would cause someone to make a transactional decision. So what you can't turn around and do is say, well, if they'd viewed the property and all my description and the pictures together as a sort of overall thing, then they wouldn't have been misled. That's not an acceptable response, because it's any transactional decision that a person makes. So even if you've produced a description online and that leads to someone to phone you or email you to inquire about a property, then that in itself is a transactional decision that would breach the obligations of the CPRs. Okay. So it's important to think about this, and trading standards do prosecute this stuff. So people think, oh, this never happens, but I've dealt with a number of trading standards prosecutions where this occurs. So it's important to think about it and to be honest about your descriptions. The other thing about the CPRs is they also have an additional element to them again, is that they also have a civil element to all of this. So there's a civil element to the CPRs, which means that if a tenant can say that they were missold the property in breach of the CPRs, then they're entitled to freely walk away from the property within the first 4 weeks of the first month of that tenancy, and have all their money back, so they can live there rent-free and walk away rent-free on the basis that they've been misadvertised or missold the property. And in fact, it goes up for longer than 4 weeks, because for a month, sorry, you can take it out to 6 weeks if I pay for what I have used. So it's not just 4 weeks; it's longer than that. But beyond 4 weeks, I have to at least pay you for what I used. So it's increasingly being relied on by tenants. I get more and more inquiries about this all the time by tenants who feel they've been missold or misadvertised property. And classic examples that come up are where landlords or agents say something's going to be repaired before the tenancy begins and it isn't, or where a landlord or agent has concealed a problem like mold by simply painting over it and it reappears a couple of weeks in. That's quite a common one, actually. Or where a landlord or agent has suggested that a feature exists or a feature or a problem doesn't exist verbally or in writing and was lying. So all of these things come up, and they are increasingly common. And it's really important that people take this into account. It is possible for tenants to walk away. It is a powerful tool. And it's important to bear in mind, of course, from a landlord's perspective, that similar provisions create rights to cancel in agency agreements. So if a letting agent or an estate agent gets you to sign their terms of business outside their office, for example, in your rental property once they've viewed it, then you have a right to cancel that contract within 14 days. And in fact, if they don't give you the information about your right to cancel, you have a perpetual right to cancel until such time as they give you the information and then 14 days have elapsed. And if you cancel within that 14 days and you haven't specifically given consent for them to do work within that time period, then you can basically not pay them. So one of the things I've seen at least twice now is estate agents who had got people to sign their terms of business, sold a house for them, not given the right to cancel, and the person selling the property then declined to pay them. Even though they'd found someone to buy it and the property had been purchased and everything, and said, well, you never gave me the right to cancel. I'm cancelling the agreement now. And I still can because you never gave me the right to cancel, and therefore I don't have to pay you at all. So it's really important to think about this if you're running an agency business, to make sure you've got your rights to cancel sorted, that you're using them effectively, and you understand when they should and should not be used. If you want an example of right to cancel, actually, if you sign up for anything with Tessa, she, I know, has her right to cancel documents in place. So if you, for example, use her service where you can ask a solicitor for advice, she actually notifies you of your right to cancel and asks you to tick a box to say that you want the service to be provided inside the initial 14-day cancellation period, so that you can get advice immediately rather than hanging around for 2 weeks before you get to speak to somebody.
Most people tick the box.
Unsurprisingly, yes, people do tick the box because they want their advice promptly. But it's a good example of a practical application of the right to cancel.
Yeah, and all of our landlord memberships, when people join Landlord Law, there's a notice on the email that goes out to them when they've just joined, telling them of their right to cancel.
Yeah, so there you are. So you can see this kind of thing in practice, and I expect many people are getting them without particularly noticing they exist. But it's really important for agents where they're dealing with people, and it's important for landlords and agents when they're dealing with tenants to realise that if they do conceal stuff and do mess about, then it is perfectly possible for tenants to take advantage of this and just walk away and not pay them.
Perhaps I might just mention there, David, that I don't think that there is any cooling off period for tenants, though, is there? That's no longer there. It used to be, didn't it, years ago? But if for tenancies themselves, tenants don't get a cooling off period.
Well, it was questionable whether distance selling regulations applied, but all of those have been ditched, and the right to cancel regulations now cover distance selling and off market sales. So in general, the tenancies aren't protected, and indeed any contract for disposition of land isn't protected. And then building contracts aren't covered by cancellation either, and neither is anything that involves a bespoke product. Most other stuff is covered, where there's a consumer involved, obviously. So the last thing I was going to talk about just briefly now, is that, of course, as I've already started out by saying, consumer law is a pretty broad term. And there is a general drive in UK law these days towards a greater degree of consumer rights, and indeed a bit of a change of approach towards tenants, where they're now increasingly being viewed as consumers, and that leads to a slightly changed attitude, which has pushed incredibly hard through its lobbying arm for tenants to be viewed as consumers, and that's had a lot of traction in government. And so a lot of legislation really presents a consumer rights function. It's either presented as consumer rights, a consumer rights purpose behind it, or contains a consumer rights element. So tenancy deposit protection, to a large extent, has a consumer rights element. It creates a system whereby tenants have an easier mechanism to recover their deposits. It also creates a civil mechanism by which they can penalise people through the 3 times the deposit penalty for breaching it. The Tenant Fees Act has a consumer rights element by removing onerous fee charging to tenants. it has a direct civil enforcement mechanism whereby tenants can one, defend against a Section 21, but also go to tribunal and get the money that they've paid back. Rent repayment orders for in England for unlicensed property are essentially consumer law, because they're there to make sure that properties are meeting a sort of minimum standard within a licensing regime, and they permit tenants to directly enforce the same their position. And then future things. So agents obviously are required to join redress schemes and have client money protection. There's a movement, and indeed the government's already committed to doing this, and is working towards having all landlords join some sort of ombudsman or redress scheme. So that is also a piece of consumer law. And then arguably things like the discussions around rent control or rent stability models. And also the ideas such as things like property MOT, where all properties will have to have a single piece of paper demonstrating their meeting of all the different property standards, are kind of seen in the same light as well. So there's a sort of general push within the PRS, particularly towards a more consumer law oriented way of thinking about things. And so it's important to bear in mind that this is not just the things I've talked about, but a general sort of move for as we go forward. So those are the 5 key points, and how and why consumer law can end up costing you money. You need to think about penalties. You need to think about the tenant and also the Tenant Fees Act in that regard. You need to think about unfair terms. You need to think about the CPRs, both in a criminal and a civil aspect, and you need to think about other pieces of regulation like rent repayment orders and deposits and so on, and all of those situations. And I'm happy to answer a couple of quick questions.
Okay, I mean, rent repayment orders, for example, can be incredibly expensive, so landlords really need to be aware of these things. Let's see. We've had a few questions here. Let's have a look. Somebody's asked where a property is fully managed, the level of obligation on agents to ensure that the EICR checks are undertaken. Or does
Well,
it
there
fall?
isn't any actually. The obligation is on landlords. The regulations require that landlords need to do it, and obviously agents will be liable to their landlords, but they've got no obligation to a local authority to get it done.
Yeah. We had a question earlier on pets. Just like to mention, I mean, pets is it's very in the news at the moment. I think because people in lockdown are on their own are desperate to have something else living with them. But for a pet's prohibition clause to be valid, it does have to be properly drafted, doesn't it, David, and to include the proper wording.
Yeah, as a rule, I mean, it's better to say that a no pets clause should say without the landlord's consent, which will not be unreasonably withheld or delayed, and then you'd have to have a reasonable reason to withhold consent. So that would be, for example, that your superior landlord didn't allow it, or perhaps that you had an allergy to pets and were planning to reoccupy the property yourself, or a number of other things like that.
Or it just wasn't a suitable property. But it hasn't. The consumer law hasn't yet gone as far as to make it a legal obligation for landlords to allow pets, which a lot of people seem to be under the impression is something that has happened, whereas it hasn't.
Yeah, there was a lot of misstatement there. It was partly the government's fault. So the new model tenancy agreement that the MHCLG has produced, which I generally wouldn't recommend people using, but the government seems to be under some belief that everyone uses it, which is kind of an evidence-free position because, in my experience, nobody uses it. It includes now a clause that allows pets, basically, and the government suggests that meant that pets were allowed, and a lot of press jumped on that, but that's absolutely not what it does, and only if you use that contract. And then there is also a private members bill that's been, sorry, it was called a 10-minute rule bill, but it was one that was introduced by an MP in Parliament that was going to force pets, but it's not a real bill. It's a 10-minute rule bill. It won't go anywhere. It has no. These are almost never picked up.
Yeah.
It's plausible the government would do something in the Renters Reform Bill, but I think that's pretty unlikely.
Yeah. So, Okay. Well, we've reached the hour, so I think probably it remains for me to say thank you, David, as usual, for coming along and talking to us and telling us about consumer law and the very expensive costs and penalties that landlords can suffer if they don't comply with them. We will be back with another lockdown learning webinar next week, and then the week after that we got another one with David, which I think is on data protection. This webinar, this webinar is being recorded and it will be uploaded to our YouTube channel, possibly later on today. And if you missed part of it, you will be able to watch it there. So there's David's details up there if you need to contact him for any reason. You can also, if you want any advice specifically from David, if you want any telephone advice, we do have a landlord law telephone advice service where you can request a telephone advice call with David. And there's a special service for HMO properties as well. So that's there for people. So thank you very much, David, and I will close down now.
Brilliant. Thank you.